Welcome to Criminal Law 101, Video 2, Actus Reus. My name is Stephanie Ledesma. I am an Associate Dean. I am a Professor of Law and an Attorney at Law. And let's jump into Actus Reus. If you watched the first video, I introduced to you this formula that I created of criminal liability. And again, it's a visual formula, right? It's a visual cue for people who are visual to kind of be able to look to see what all the different pieces of criminal liability include. And that's why I share it with you. As you will see, the very first part of the formula is Actus Reus, and that is where we are starting today. So let's get to it. Actus Reus. What is a voluntary act? Well, that's a really good question. And hopefully we can answer it. By the end of this video, we're going to go through several categories of Actus Reus. And the reason we're going to go through those several categories is because these are the categories that are most addressed in Criminal Law 101. Okay, so we didn't just pick these categories because we thought that they were cool. We actually picked these categories because these are the ones that we are going to address in Criminal Law 101. What are the categories? 1, a voluntary act. 2, unconsciousness as a voluntary act. 3, possession as a voluntary act. 4, status as a voluntary act. And 5, omission as a voluntary act. Let's get started. Start with the definition of the thing always. If you start with the definition of the thing, you get a better sense of strategically where you should line yourself up to start in your analysis and in your application and in your practice. So we're going to start with the definition of Actus Reus. It is a Latin term for guilty act. Actus Reus addresses the voluntariness of the crime, okay? Voluntariness of the crime. Stop right here, take a breath, find your feet. Voluntariness is not indicative of intentionality. What? Voluntariness is not indicative of intentionality. If you as a lawyer or law student are talking about voluntary, you are necessarily talking about Actus Reus. If you are talking about intentionality, you are then talking about mens rea. So let's make sure we know where we are. Right? We're not going to drift or leak, right? Or go into those other places and spaces. We're going to stay right here, Actus Reus, voluntariness. Now, each of those elements of the criminal liability formula have to be established by reasonable doubt. I introduced the term here. I realize this is not criminal procedure, where you're going to talk a lot about reasonable doubt. But I introduced the term here so that you can start to become familiar with this burden of proof. And I put a little chart there to the side to kind of give you a sense of, well, what does reasonable doubt really mean? It means that it's none of those things in the chart, and it's the one right at the top. All right, so the voluntariness of the act must be established by reasonable doubt. All right, well, let's talk about the voluntariness of the act. What does the Model Penal Code say about Actus Reus? Stop, practice note. The Model Penal Code is exactly what it says. It's a model. Right? It is if it were the gold standard, right? If everything about it could be all that it could be. This is the gold standard of what criminal laws will look like. Some states have adopted the model penal code as their criminal code. If the state has adopted the model penal code as its penal code, then that's the law, okay? Some states use the model penal code as a template, as an example, right? Oh, I like this language. Let's take that language and use it as ours. Oh, but I don't like that language, so we're not going to use that, right? So if the state has not adopted the model penal code for its state, then the model penal code is nothing more than a model, right? So file that away. It will come to be used later on in the semester, but important note, file it away. Here we go. How does the model penal code, right? This is the gold standard of what penal code should look like. How does the gold standard of criminal codes define voluntary act? Here we go. Not guilty of a voluntary act unless criminal liability based on conduct that includes a voluntary act, okay? Well, let's go to the next paragraph to see if it's any clearer. Model Penal Code 2.012, the following are not voluntary acts. Get used to it, right? The law will oftentimes define a thing by telling you what it's not. That's okay. That's okay. What you will realize is that actually gives you a lot of freedom, creativity, and room to move within what appears to be a very rigid system of dictates. But 2.012, the following are not voluntary acts: reflex or convulsion, bodily movement during unconsciousness or sleep, conduct during hypnosis or resulting from hypnotic suggestion, bodily movement that otherwise is not a product of the effort or determination of the actor, either conscious or habitual. Okay, there you go. Does that help you when you start to look at hypotheticals and you know that the first thing that you have to do is to determine whether or not the defendant acted voluntarily? Does that help? It's okay to be honest, because it didn't really help me. So here we go. Let's do what we do to really get better understanding of what the law is. We're going to go to a case. What case are we going to go to? We're going to go to the Martin v. State case. Why? It's a pretty simple case, okay? We're looking back at Model Penal Code 2.011, where it says not guilty unless criminal liability based on conduct that includes a voluntary act or omission when there is a duty to act. Remember, that is the Model Penal Code definition that we're going to use. So let's get into Martin v. State. One thing that I want you to notice, again, something for you to file away to be able to use at a later date. Look at the style of the case, Martin v. State. We already know that it is the greater protector of society that is the one that prosecutes cases, whether that's the Queen, whether that's the district attorney's office, whether that's the U.S. attorney's office, whether that's, right, the state versus Ledesma, or the Queen versus Ledesma. But what do you have right here? In Martin v. State, you've got the parties mixed almost, or switched, right? You've got Martin, who you assume is the defendant because it's a proper name, and then you have State. Well, shouldn't that be State v. Martin, was that a typographical error? Do we really care? We do. And that when you see the style of the case, a criminal case like this, where the defendant's name comes before the state or the prosecuting agent, then you know that that's an appellate case, right? Because Martin is the one who's bringing the case. So his name would go first in the style because this is an appellate case. But again, just something for you to store away. What's the legal issue? You and I have already talked about the way that I set up legal issues, right? So here's my under does when. The does has been replaced by a be verb. The be verb is here. Under the law, is defendant guilty of being drunk on a public highway when the defendant was on the public highway involuntarily? Remember, I said the under is always the law. The is the thing that's being questioned. And the when are those dispositive facts, those key facts, right? Because just by reading that legal issue, you almost say to yourself, oh, well, this wouldn't be an issue at all if he wasn't on the public highway. It seems that him being on the public highway seems to be a big deal. All right, well, let's get in it. What is the rule of law? How did I find the rule of law for Martin v. State? I looked at the case, the actual case, right? Sometimes you will see it if you're using your book and you use the snippet of the case that's included in the book, right? The book can't reproduce in full every case that it uses because the book is already kind of large and heavy and expensive. Could you imagine if it reproduced the entirety of all of the cases that it addressed? Yeah, no, we can't do that. But for learning purposes, sometimes you've got to go beyond what you're given, right? Sometimes you gotta go extra. And as a law student, knowing that I have the access to Lexis, knowing that I have access to Westlaw, knowing that I have access to all of these other different venues, it's really easy to pull that case up so that I can get a better understanding because now I've got a greater sense of the context of the case, okay? Practice note. Here we go. Code 1940, Title 14, Section 120. Here is the rule of law. The rule of law says, any person who, while intoxicated or drunk, appears in a public place where one or more persons are present and manifests a drunken condition by boisterous or indecent conduct or loud and profane discourse shall, on conviction, be fined. That's the rule, right? So if you are drunk and if you're in public where there's one or more people and you're acting a nut, right? You're being loud, you're being boisterous, you're using indecent conduct. If you're arrested, if you're charged, if you're tried, and if you are convicted, your punishment will be a fine, right? I got to go through all of those ifs, but this is the law. What are the key facts, right? Because the law without the key facts doesn't mean anything. And while all facts may be interesting, some facts are more interesting than others. Some facts are really interesting. All facts don't carry the same weight. All facts don't carry the same priority. Part of your job is to learn how to analyze facts, right? How do I determine which facts are important? I look at the law that we're focusing on. So the law that we're focusing on is a public intoxication law, right? If there's facts in here about how beautiful the neighborhood is that this person lives in, that's not relevant to the public intoxication law and the conduct required, right? If there's facts in here that talks about this person's phenomenal education, that's not relevant, right? It might be interesting if there's facts in here that says that this person is dating this amazing person. Well, that might be interesting, but it's not relevant. So let's look at our quote unquote good facts that help support the allegation. Allegation, drunk in public. Let's look at the facts that support that he was drunk in public, right? Here we go. The defendant was at home when he was drunk. Law enforcement went to the defendant's home and arrested him. Okay. Law enforcement took defendant from the home onto the public highway because he was under arrest, right? While on the public highway, the defendant manifested a drunk condition. Well, he was drunk when they took him from the house, right? And he continued to manifest that drunk condition by using loud and profane language. Oh, okay. Well, he's drunk and he now is manifesting that behavior by using this indecent language, and he's acting boisterously. The defendant is then convicted of being intoxicated on the public roadway. Problem: where's the Actus Reus? Where is the physical act that the defendant took? What is the thing that the defendant did as it relates to this crime that he did voluntarily? Anybody? Thoughts? Is it the drinking? Well, this isn't a rule or a law about drinking, right? It's about being drunk in public. Oh, well, he was drinking, so he's drunk. Well, we assume drank voluntarily, but it's only a violation of the rule if he's drunk in public. Okay, so let's focus on the in public. How did the defendant get in public? He was carried by police because he was placed under arrest. And the route that the police took put him on the public highway. And he's before two police officers yelling and screaming and cursing. Yeah. All right. But was the act of being in public one that the defendant did voluntarily? All right, let's look at the court's analysis. The court says that the plain terms of the statute, voluntary appearance on the public highway, is presupposed. An accusation of drunkenness in public cannot be established if the accused was involuntarily and forcibly carried to the public highway. What does that mean? That means that the defendant did not act voluntarily to put himself in the public, on the public highway. Because there was no voluntary act, we cannot satisfy the criminal liability formula, right? So there is no crime. Got it? Oh my God. Do you feel excited? Do you feel like your brain is on fire, right? On fire, on fire. All right. So there's an example of a voluntary act. Let's go to something just a little bit more complex. Let's go to unconsciousness as a voluntary act. Okay. Now, how does the model penal code define unconsciousness? Or what does the Model Penal Code say about unconsciousness being a voluntary act? The Model Penal Code says 2.012b, the following is not a voluntary act: bodily movement during unconsciousness or sleep. Boom, letters on the page, black and white, little bit of red mixed in, but here it is. Got it? Can't be a voluntary act if it's a bodily movement during unconsciousness or sleep. So if it's a bodily movement during unconsciousness or sleep, we don't satisfy the first element of our criminal liability formula, which means we don't pass go, we don't get $200, we don't continue to play. Yeah. Now I look at that and that looks pretty plain. So if something happens, if there's a movement of my body, this is an external movement, this is an act. If I'm unconscious or if I'm asleep, that really seems pretty straightforward. Yeah. Well, welcome to the world of the law. Let's go to a case, Fulcher v. State, so that we can really get a better understanding of what unconsciousness as a voluntary act looks like. Fulcher v. State. Here we go. What is the legal issue? I didn't do the under, but I could very easily say under Wyoming Annotated Statute, section 64506A, does a defendant act voluntarily when their action takes place while in a state of unconsciousness? Well, the answer is no. Well, I don't know. I've got to analyze it. So let's jump into the analysis. This is the best part. Let's look at our key facts. Key facts. Defendant and his friend are at a bar. Defendant claimed that he had been in a fight earlier that evening. Defendant claimed that he didn't remember the fight itself. He just remembers waking up in jail because he and his friend had been arrested outside and behind the bar. Okay, so stop. Friend and friend at the bar having some drinks. Defendant gets into a fight. Defendant doesn't remember the fight. Defendant doesn't remember leaving the bar. Defendant wakes up in jail. Okay. Defendant is told that during his arrest, he was uncooperative, he was combative. Defendant was placed in a jail cell with another person who was unconscious at the time. And so there we are. We've got two people in the cell, one person is unconscious, and you have the defendant. At some point, the jailer hears some noise that sounds disturbing. So the jailer goes to look to see what's going on. And the other person in the jail cell is on the floor, but the defendant isn't in the midst of doing anything other than standing there, right? And I think it was at this point that the defendant may have said that the person fell out of the bed. Jailer walks away, doesn't go too far, hears this disturbing sound again, and jailer comes back. And at this time, the jailer sees, personally observes the defendant kicking this other person in the head. Kick this other person in the head so damagingly that this other person wound up going to the hospital and had to receive 52 stitches. Okay, so initially, the defendant was jailed for probably public intoxication, right? Now, having kicked this other person who was in the jail cell with him in the head, to the extent that he did, the defendant is now facing aggravated assault charges without a dangerous weapon. Okay, so those are the charges. Here's the question. Is the defendant criminally liable for an act that would have been kicking in the head if he committed that act while he was unconscious? Well, let's keep going. The defendant was indicted and charged with the aggravated assault. The defendant then went to trial on that aggravated assault. Prior to that, however, when the defendant got out of the sober tank, he went home, had an appointment, went to go see a doctor. The doctor said that the defendant had a concussion from the fight. Okay. The doctor described what had happened with the defendant as traumatic automatism. Traumatic automatism. I'll say it one more time. Traumatic automatism, which for all intents and purposes is akin to unconsciousness. All right. Ledesma, tell me more. I'll be happy to tell you more. The defense of unconsciousness is an affirmative defense. It's also a complete defense. Well, let me back up. An affirmative defense, what does that mean? That means it is a defense that I can allege as a defendant or a respondent to a lawsuit, but I now have the burden of proving whatever the elements of that defense is. Okay, so what we have is a defendant who had been diagnosed with a concussion as a result from the fight before, a defendant who's been diagnosed with traumatic automatism, which is akin to unconsciousness, and unconsciousness, if proven, because it's an affirmative defense, is a complete defense. Okay. What happens in this trial? Remember what we're focusing on. We are focusing on the voluntariness of the act. We are not focusing on intent. We're focusing on the foot kicking the head of the other person. Don't allow yourself to seep in to mens rea. Stay right here with us in Actus Reus. Okay, let's go back to the expert witness and let's see what the expert witness can help us understand. That's the purpose of an expert witness. Expert witness testified. The defendant suffered a brain injury during the fight. Got it. Got a brain injury. Defendant was in state of traumatic automatism at the time of the attack because he had a brain injury. That's the concussion. Traumatic automatism causes a person to not have conscious or willful control over what? Not their thoughts, but their actions. Not their thoughts, but their actions. Traumatic automatism causes a person not to have conscious or willful control over their acts. Traumatic automatism causes a person to lack the ability to be aware of external environment, right? So I don't know what my extremities are doing. I am not aware of what's happening externally. I have no idea that my foot is doing that thing because I am not connected to myself. Got it? Automatism may be caused by mental disease, or it may be caused by trauma to the brain. Okay. Well, I get into a fight, I get into a concussion because my brain has been traumatized and now I can't remember anything. I have no ability to will my feet, my hands, my toes to do anything because the connection isn't happening, right? Automatism, again, may be caused by mental disease or trauma to the brain. Automatism, like unconsciousness, is a complete defense. Automatism, like unconsciousness, is an affirmative defense. An affirmative defense means that the burden rests upon the defendant to establish, right, the elements of that defense. Got it? This is what you need to know about expert witnesses. Expert witnesses get to come in and give their expert opinions on things related to the merits of the case. Lay people can't give opinions. Expert witness can give opinions. So this doctor, even though the doctor didn't observe the defendant in the bar fight, even though the doctor didn't observe the defendant getting this head wound, even though the doctor didn't observe the defendant kicking the other gentleman in the head, the doctor can take information from all of these sources and rely on that information to make an opinion, and an opinion that has some weight to it because he's an expert witness. Yeah, but this is it. The trier of fact is not bound to accept the opinion, right? Especially in the face of other substantial and credible evidence. So even though the doctor came in and said, dude had traumatic automatism, because he had traumatic automatism, he had no control over anything that his body did. He was unaware completely of any of the acts that his body partook in. I can't say for certain that he wasn't aware that he was kicking the guy in the head and resulted in the guy having to get 52 stitches. But I can say in my phenomenalness as a doctor that it is possible that he didn't know what he was commanding his body to do. So the actions taken by his body were not being willed by him, right? It's possible. The other substantial and credible evidence that we can't forget is that the first time that the jailer came by to see what was going on in the jail cell, the defendant said that the guy had fallen out the bed. So it seems like he's together in his place and space, right? When the jailer came back the second time, he saw the defendant kicking the guy. There was nothing to indicate that the guy stopped kicking or that the guy continued to kick, even though he was present with the police officer, right? So it's like, if I'm doing something wrong and I know that I'm doing something wrong, I stop doing that thing when I think that I'm caught, right? It's just natural. I will stop kicking you if I think somebody's watching me because I know that kicking you is the wrong thing to do. But if I'm unaware that I'm kicking you, why would I stop, right? So there's so much other credible evidence going around here that the court said, thank you, doctor, for your time. Thank you for your patience. Thank you for your contributions today. However, we're not going to buy it, right? And the court did not buy the unconsciousness traumatic automatism defense. The court's analysis was supported by their statement For unconsciousness to be a defense, absent mental disease, the intent is that the trauma is more than temporary or transitory condition, which they found his condition to be, right? So Fulcher v. State gives us an understanding of what unconsciousness is supposed to look like in order for it to be deemed not a voluntary act, right? And they showed us by showing what doesn't work. Yeah. Again, this is Fulcher v. State. You see that his name is listed before State, which tells us what? That this is another appellate case. Not a problem. How's everybody doing? We're about halfway there. Woo, let's take a breath. Let's breathe in. Bring your hands on top of your head. Breathe out. Woo, let's let it go. Let's do it one more time so we can reposition ourselves in our chair. We can get reinvigorated. We can get excited about this one more time and go. We have looked at a voluntary act. We have looked at unconsciousness as a voluntary act. Let's look at possession as a voluntary act. Let's go to the Penal Code, where the Penal Code explains to us in section 2.014, possession is a voluntary act if the possessor knowingly obtains the thing being possessed, procure. The possessor knowingly receives the thing being possessed. The possessor is aware of his control of the thing for a sufficient enough time that he can terminate his control of the thing. Get it? So, possession for criminal liability purposes can be a voluntary act that satisfies the Actus Reus portion of our formula. But the only way that possession, which seems to be more of a benign activity, right? But it's an activity, it's an action, Actus Reus. In order for possession to be deemed a voluntary act, the possessor has to either know that they've obtained it, whatever it is. They either have to know that they received it, whatever it is, or they have to know, be aware that they have control of whatever the thing is that's being possessed long enough to be able to terminate that control if they choose. Yeah? Sounds good. However, I don't really know what I think that I know until I put it in a case and see what it looks like once it takes on breath and life, right? So let's put this Model Penal Code 2.014 into a case and see what it looks like. People v. Gorey. What is the legal issue? Does the defendant commit the act of possession, right? Does the defendant commit a voluntary act of possession when he has no knowledge? Got a typo right here. Nice. We'll fix that on the other end before we post it. When he has no knowledge of the existence or presence of the thing, he doesn't have any knowledge. He doesn't have any knowledge of the existence. He doesn't have any knowledge of the presence. So can he be convicted of a crime that includes possession if he doesn't know that he has it? Well, we looked at the family code already. Take a breath. We looked at the penal code already, right? And in the penal code it says you got to know some things. So what are we looking at? What is the rule of law? Section 4573 of the penal code for the case that we are looking at now, which is People v. Gorey, unlawfully bringing marijuana into a prison farm. Okay, that was the first code violation that the defendant was charged with. The second code violation was Section 11160 of the Health and Safety Code, willfully, unlawfully, and feloniously having in possession flowering tops and leaves of Indian hemp, commonly called marijuana. Well, let's see what this possession looks like. What does the possession look like? Defendant was found guilty of possession of marijuana. He appealed, and he's inciting jury instructions as the problem. Defendant was a prisoner at the LA County Honor Farm. Defendant shared a living quarters with 30 other prisoners. All the prisoners were issued metal boxes. This is where they were supposed to put their toiletries and their personal belongings. The boxes don't lock. When the defendants are out doing their jobs and their duties, there's one person that's left there at the barrack, at the dormitory, to make sure that there's no hanky-panky weird stuff going on, right? You know, nobody's stuff is getting bothered and everything. But for all intents and purposes, everyone has access to everyone else's box, okay? Now, in the trial for his alleged violation of those two codes, the court, before turning the case over to the jury, does what all courts do, read the jury instructions. It appeared that the court read the instructions out loud. It appeared that the court reread the instructions out loud. And then it appeared that the court withdrew one of the instructions. The instruction that the court withdrew was instruction 12. Knowledge of object is a prerequisite to dominion and control. The judge withdrew that. And so once the jury got the charge, the jury no longer had to make a finding of knowledge of the object, right? So the judge's instructions were the exact opposite of what the model penal code says should happen, which is you got to know that you obtained it, or you got to know that you received it, or you got to know that you have it in your control for long enough to have gotten rid of it. And that doesn't seem to be happening in this case, because some of the additional facts were, when law enforcement came and did the inspection and they found the marijuana in the defendant's box, it was thrown throughout the box. It wasn't in a hanky or a little wrappy or a little baggie. It was just kind of all over the box, right? And then the officer that found the marijuana in defendant's box examined the defendant, found no marijuana, asked the defendant what he knew about the marijuana. The defendant said, I don't know anything about the marijuana, right? So there's nothing, there's no facts to support, that the defendant knew that he had obtained the marijuana, knew that he had received the marijuana, or knew that there was marijuana in his control. There's no facts to support that, okay? And once the trial court took away the instruction of knowledge, that was instruction number 12, that the defendant had to have knowledge of the existence of the marijuana, when the judge took that out as a required finding, what was left with, almost, you would think, what would be more akin of a strict liability crime almost, but again, that would go to intentionality as opposed to voluntariness. So the court's analysis. Knowledge is a basic element of possession. Knowledge of the existence of the object is essential to physical control. Knowledge must necessarily precede the mens rea, the intent, to exercise control. The word knowingly imports only a knowledge of the existence of the object. In withdrawing jury instruction number 12, that required the jury to find that the defendant knew of the existence of the marijuana, which was proper, became a failure when it was removed because it likely misled the jury to believe that knowledge was not essential, right? Knowledge was not an essential part of the crime. And since knowledge was an essential part of possession, he could not been criminally liable because there's no facts to support that he had knowledge. So that is an example of possession as a voluntary act. If you've got knowledge, possession may be a voluntary act. Without knowledge, possession cannot be a voluntary act. Let's look at status as an act. Status as an act, right? The status of being. Real simple case, Robinson v. State of California. Not going to spend a lot of time on this one. Robinson v. State of California. The defendant was convicted by a jury of being an addict. This ultimately became a United States Supreme Court case. Okay, what are the facts? Law enforcement found the defendant laying around outside, arrested the defendant. Upon the arrest, looked at the defendant's arms, noticed scar tissue and discoloration and numerous needle marks, right? At some point, the defendant admitted that he occasionally used narcotics. What is the law that supported this arrest and this conviction? The law in California said it was a misdemeanor to be addicted to the use of a narcotic. Didn't say it was a misdemeanor to use narcotics. It says it was a misdemeanor to be addicted to the use of narcotics. And a little bit more about the law was that it didn't matter if you became addicted in California or addicted in some other state. As long as you were addicted, you were going to be charged and convicted of this crime. Again, went up to the United States Supreme Court, and the United States Supreme Court said to be addicted is a status. It's a condition. It's a disease. It's continuing. It's chronic. It's not acute. It is not one and done. It is constant, right? And as a result, that's not a voluntary act. You cannot voluntarily be addicted, right? It is a disease that requires treatment, not an act that deserves punishment. So that's what status as a voluntary act looks like. It doesn't look like anything because it's not a voluntary act. Okay. Last one, omission as an act. What does the Model Penal Code say about admission as an act? Model Penal Code 2.013 says, liability for the commission of an offense may not be based on an omission, unaccompanied by action, unless the omission is expressly made by sufficient law defining the offense, or ding, 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 here's the one that we focus on, or the omission is to a duty that you are required to perform. A duty to perform. A duty to perform. When would you have a duty to perform such that non-performance would be considered a voluntary act? Let's look at Jones versus the United States. Issue: does a caregiver owe a duty to act on behalf of a minor child such that when the child dies under the care of that caregiver, the caregiver can be held responsible for the child's death? I'm a caregiver, I have a child. Is there a duty for me to act in order to keep this child safe, such that if I don't act, I omit to act, and the child dies, that I can have criminal liability and be bound over for trial? Jones v. United States. Here's the rule. There's 4 circumstances where a failure to act constitutes a breach. Here you go. 4 circumstances where failure to act constitutes a breach. If there's a statute that says you're supposed to act, if there is a status relationship, if you have assumed the responsibility to act via a contract, or if you have voluntarily, no contract necessary, assumed the care of another and secluded that person such that no one else can help, well, then it's on you. Omissions. State imposes a duty and you don't do it, you omit. There's a relationship which infers a duty and you don't, you omit to act. You have assumed by contract to act on behalf of this person and you omit, you fail to act. Or you have voluntarily assumed the care of someone and that someone is so secluded that no one else could help if help was needed, right? Then your omission satisfy the Actus Reus, which may lead to you being found criminally liable, all right? Let's look at Jones v. United States. What are the key facts? Shirley Green had 2 children. Shirley Green had a friend. This is the appellant. The appellant cared for both of Shirley's children. Okay, so Shirley had 2 kids. Shirley wasn't taking care of the kids. Shirley took the kids to her girlfriend's house, the appellant / defendant, and gave defendant responsibility to care for the children. 2 children, Robert and Anthony. Anthony, the youngest child, 10 months, died of malnutrition under the care of the appellant / defendant, okay? Substantial evidence showed that the appellant / defendant failed to gain proper medical care for this child. And then there was some back and forth that the appellant didn't feed the child. She said, I did feed the child. I have a boarder who was at the house who can come in and testify that I fed the child, but the child still died of malnutrition. The appellant takes issue that the defendant did not charge the jury with an instruction that said, before you can find that she failed to do this thing that led to the death of the child, you have to first find that she had a duty to act. Now, the judge didn't put that in the jury instructions, and that's what the appellant / defendant is appealing. She said, but you should have, right? You should have said, you should have made them first find that I had a duty to do anything for that kid. And then, and only then, if they found that I had a duty to do something to this kid, can they judge me for not doing it, right? That was her complaint. Judge said, hogwash. Hogwash. Let's go back. Is there a statute that imposed duty for her to get medical care and make sure that the child had adequate nutrition? Not that we see from the facts that were provided. Is there a relationship that would infer that she had an obligation, a duty to make sure that this child was nourished? Yeah, child was living in her house with his brother. Miss Green was nowhere around. Read the facts. Miss Green hadn't seen the kids. Miss Green gave birth to Anthony, the youngest, stayed with Anthony at the friend's house for 3 weeks, and then she went back home. Miss Green went back home to her parents, childless, because she had left the children in the care of the defendant, right? So the only way these children get any sustenance is through their relationship with the defendant. The only way these children get care is through their relationship with the defendant. The only way these children get medical care is through their relationship with the defendant, right? There's no other way. And there's testimony that the gas company representative came down to check the gas with the house, and they saw the oldest child in a cage, and they saw Anthony in the bassinet all shriveled up with roaches all over him. Right. So even though there's no statutory imposed duty, there's that status relationship. Let's just, for the sake of analysis, go to the third piece. Was there a contractual duty? Well, the facts indicate that Miss Green, the mom of these children, agreed to pay the friend $70-something a week or a month for the care of the oldest child. There's no indication that there was any such agreement for the second child, but the defendant took in the second child. So even if I can't say that there's a contractual duty, clearly there's a status relationship, right? And let's go to the fourth one, where one has voluntarily assumed the care of another and so secluded the helpless person as to prevent others from rendering aid. The defendant had the children in her possession. Oh, wow. Let's go back to possession. We know possession is knowing that you've got the thing, right? She had the children in her exclusive possession. So the status relationship, the relationship between them was enough to establish that the appellant / defendant had a duty of care. Okay. One thing before we end, I wanted to go back to this case, the Jones v. US, where we're talking about the defendant being an appellant. Again, Jones v. United States, look at the style of the case. That means that Jones, that's the defendant, is first, which means this is an appeal, right? And once you have an appeal, whoever files the appeal becomes the appellant. I know you haven't gotten there yet, but we're using terms of art that you will soon become familiar with. So you might as well get familiar with them now, as opposed to just kind of reading over them. That's what all of that means. So as we conclude video 2, what did you learn? You learned the definition of Actus Reus. You learned what Actus Reus, the voluntary act, looks like. You learned what unconsciousness as a voluntary act looks like. You learned what possession as a voluntary act looks like. And you learned what status as a voluntary act looks like. And you learned omission and what an omission as a voluntary act looks like. That brings us to the end of video 2, which brings us to the end of Actus Reus. It has been an amazing, amazing ride. If you have questions, please feel free. Shoot me a note in the chat or send me an email, and I'll be happy to respond. Thank you so much.